Before we dive deep today, let your curiosity guide you over to the All Sorts podcast on YouTube. Think of it as this amazing library, and all you need is a click like, share, subscribe. It really helps weave you into this tapestry of knowledge we're building. All the past deep dives are there, ready for you to explore. And, if you want to connect more, find us on X, Instagram, and Threads. Join the All Sorts podcast community. Your curiosity, honestly, it fuels everything we do.
Absolutely.
So welcome the learner. This deep dive is specifically for you. Today we're tackling something incredibly complex and, frankly, urgent. International humanitarian law, the role of international courts, all in the context of the Israel-Gaza situation.
It's a heavy topic, and to help us navigate it, we're looking at several key sources. We've got the Fourth Geneva Convention, naturally, information from the International Court of Justice, the ICJ,
Right.
analysis from Human Rights Watch, some perspective from the University of Melbourne on the ICJ and the ICC, the International Criminal Court. Plus, a very recent humanitarian situation update from OCHA on Gaza, and news reports covering the current ICJ hearings.
So a lot to draw from. Our mission really is to pull out the most critical bits, help you understand the legal frameworks, the discussions happening right now about the humanitarian crisis without, completely overwhelming you.
Trying to find clarity in the complexity.
Exactly. Okay, let's get into it. Let's start with that foundation. The Fourth Geneva Convention, GCIV, adopted 1949, came into force 1950. This was huge, right? The first one really zeroing in on protecting civilians in war zones.
It was landmark. And the fact that 196 countries are party to it, that says a lot about its importance.
Definitely.
So, Part I lays out the general provisions. Article 2 is crucial. It sets the scope. It applies to declared war, yes, but also any other armed conflict between signatories and, importantly, occupation of another country's territory.
Occupation being key here.
Very key. And interestingly, even if one side in a conflict isn't a signatory, the others are still bound by it amongst themselves. It shows the shift towards the convention's upholding principles, not just being like tit-for-tat contracts.
That's a powerful idea, an inherent ethical layer.
Yeah.
Then Article 3 deals with conflicts not between nations, non-international ones.
Precisely. Article 3 sets a minimum standard of humane treatment for people not actively fighting civilians, captured soldiers, the wounded. It prohibits violence, murder, mutilation, torture.
The absolute basics of humanity.
Yes, and also hostage-taking, humiliating treatment, and sentences without a proper trial. A baseline decency even in the midst of conflict.
Okay, so who exactly are these protected persons the convention talks so much about? Article 4.
Right. Article 4 defines them. Essentially, individuals who find themselves in the hands of a party to the conflict or an occupying power, of which they are not nationals.
So in this context, we're largely talking about Palestinian civilians in relation to Israeli forces.
Generally, yes. The article does exclude nationals of states not party to the convention or neutral states with normal diplomatic ties because, their own state can theoretically protect them diplomatically. But for Palestinians in Gaza and the West Bank, this definition is critical because so many GCIV rules apply specifically to protected persons.
And there's a narrow exception, Article 5, something about security.
Yes, Article 5 allows for a very limited temporary suspension of certain rights for someone genuinely suspected of hostile acts like spying or sabotage if it's absolutely vital for state security.
But even then,
humane treatment and fair trial rights must be upheld. Legal interpretation really stresses how narrow this exception is. It's not a loophole to ignore basic protections. Debates around this often center on what counts as genuine suspicion versus collective suspicion, and ensuring due process isn't sidelined.
that raises difficult questions, especially in active conflict zones. Okay, moving to Part 2, this seems broader, protecting whole populations.
It is. Article 13 makes it clear. Part 2 applies to everyone in the conflict countries. No discrimination allowed. Race, religion, nationality, politics, none of it. The goal is simply to ease the suffering caused by war.
And protecting the wounded and sick, Article 16.
Yes, protecting and caring for them. It even mentions respecting the dead, basic human dignity.
Now, Part 3 gets really specific about the treatment of these protected persons. Articles 32 and 33 seem incredibly relevant today.
Absolutely fundamental. Article 32 forbids anything causing physical suffering or extermination. It lists things like murder, torture, corporal punishment, mutilation, non-medical experiments. No ambiguity.
And Article 33?
Also vital. It establishes individual responsibility. You can only be punished for what you personally did. And crucially, it explicitly bans collective penalties.
Collective punishment. We hear that term a lot.
Yes, and GCIV prohibits it, along with intimidation, terrorism against protected persons, pillage, reprisals against them or their property. Banning collective punishment was a direct response to atrocities in past wars, trying to prevent mass retribution against whole populations.
So when you hear about things like widespread aid restrictions impacting an entire population,
Legal scholars definitely look at that through the lens of Article 33. Is the impact so broad and severe that it functions as a collective penalty, even if not explicitly stated as such? It's a serious question under IHL.
it connects directly. Okay, Section 3 of Part 3 focuses on occupied territories. Article 49, deportations, transfers, evacuations. This feels central.
Extremely central. Article 49 flat out prohibits forcible transfers or deportations of protected persons out of occupied territory, period, regardless of motive.
But there are exceptions for evacuation.
Very narrow ones, if the population's security or imperative military reasons demand it. But even then, evacuations should ideally be within the occupied territory. Moving people outside is only allowed if materially impossible otherwise.
And they have to be allowed back.
Yes, as soon as hostilities in that specific area end. The occupying power has duties too. Ensure proper accommodation, hygiene, safety, food, and keep families together. And crucially, the occupying power cannot deport or transfer parts of its own civilian population into the occupied territory.
That's the settlements point again.
Exactly. The ICRC explicitly calls establishing settlements a prohibited population transfer under Article 49. The legal implication is stark.
Very clear. What about protections for children under occupation? Article 50.
Article 50 puts a duty on the occupying power to help institutions caring for and educating children. They have to help identify children, register parentage, and they can't change their personal status or enlist them.
Right.
If local institutions aren't enough, the occupier has to arrange for their care and education, preferably by people of their own background. And they can't hinder any pre-existing special measures for kids under 15, expectant mothers, or mothers of young children.
Article 51 touches on compelling people to work or serve in forces.
A definite no on compelling service in the occupier's armed forces. Propaganda for voluntary enlistment is also banned. Compelled work is allowed only for those over 18, and only if it's necessary for the occupation army's basic needs, public utilities, or essentials for the local population, food, shelter, etc.
But not military operations.
Correct. Can't involve them in military operations or force them into work for the occupier's security. Work must be within the occupied territory, paid fairly, with proper conditions. No militarized labor mobilization.
And destroying property. Article 53.
Prohibited unless absolutely necessary by military operations. This specifically protects property in occupied territory from the occupying power, different from the general rules of targeting during hostilities.
Okay. And health services. Article 56.
The occupying power has a duty, using the means available, to ensure medical services, public health, and hygiene. They need to cooperate with local authorities, combat disease spread, allow medical personnel to work, and respect local ethics.
And finally, Article 78 on internment.
Allows internment or assigned residence for imperative reasons of security, but again, individuality. No collective punishment, no measures against people for things they didn't personally do. It has to be based on individual assessment.
That gives us a strong grounding in GCIV. Now, let's pivot to the international courts. The International Court of Justice, the ICJ. What's its role?
Okay, the ICJ. Based in The Hague, it's the UN's main judicial body, set up in 45. It does two main things. Settles legal disputes between states based on international law, and gives advisory opinions on legal questions when asked by authorized UN bodies.
Key phrase. Between states.
Exactly. Only states can bring contentious cases. Individuals, NGOs, companies, they can't directly sue another state at the ICJ, though a state can take up its national's case.
So totally different from the International Criminal Court, the ICC.
Completely different. The ICJ does not try individuals for war crimes or crimes against humanity. It doesn't have a prosecutor. That's the job of national courts, special tribunals, and, yes, the ICC. The ICJ is also distinct from, say, regional human rights courts that might hear individual complaints. Its jurisdiction is general international law between states. It's not a Supreme Court for national systems.
How does a case even get to the ICJ then?
Only when the states involved have consented to its jurisdiction. This can happen through a special agreement for a specific case, a clause in a treaty they've both signed, or through unilateral declarations accepting the court's jurisdiction in relation to other states, making similar declarations the optional clause.
And are its judgments binding?
In contentious cases between states, yes. The judgments are binding on the parties and there's no appeal. The UN Charter even says members agree to comply. Advisory opinions, though, are technically non-binding.
But they still carry weight.
Oh, absolutely. They carry significant legal and moral weight. It's up to the UN bodies that requested them how they act on them, but they often influence international law and policy.
We're hearing a lot about the ICJ in Israel-Gaza right now. What are the current hearings about?
Right now, the ICJ is holding hearings specifically looking at Israel's humanitarian obligations towards Palestinians. This came from a request by the UN General Assembly.
Right.
The trigger was concern over aid restrictions to Gaza and the West Bank, especially after Israel reportedly blocked UNRWA, the UN Agency for Palestinian Refugees, from operating in its territory.
Who's involved in these hearings?
The UN itself, Palestinian representatives, and about 40 other states and international organizations are participating. Israel chose not to speak, but could submit a written statement. The U.S. is participating too, even though they voted against the initial UN resolution.
And what are people saying?
Well, reports mention a Palestinian envoy telling the court that Israel is killing civilians and targeting aid workers, calling it a man-made catastrophe. On the other side, Israel's foreign minister reportedly called the hearings systematic persecution, suggesting the court is being politicized.
Even if the final opinion is non-binding, what impact could it have?
Experts think it could still be significant. It might shape future legal interpretations of occupier duties, potentially affect international aid decisions regarding Israel, and definitely influence public opinion and diplomatic pressure.
But the actual effect on policy
Remains uncertain. History shows states don't always comply with ICJ rulings or opinions, as seen with the 2004 opinion on the West Bank barrier, for instance. And it's vital to remember these hearings are separate from the other big case.
The one brought by South Africa.
Yes, the case where South Africa alleges genocide. These current hearings are focused specifically on humanitarian obligations under occupation law and general international law. Different legal questions.
Okay, distinction made.
Right.
You mentioned the ICC earlier, the International Criminal Court. Remind us of its role here.
The ICC prosecutes individuals for the big four international crimes: genocide, war crimes, crimes against humanity, and the crime of aggression, though the latter is complex.
Then how does it get involved?
The prosecutor can open investigations if the alleged crimes happen in a country that's ratified the Rome Statute, the ICC's treaty, or if the UN Security Council refers a situation.
Is Israel a party or Palestine?
Israel is not a party to the Rome Statute, neither are Russia, the U.S., or Myanmar, for example. However, the state of Palestine is a party.
Ah, so that gives the ICC jurisdiction.
Yes. Because Palestine is a member state, the ICC prosecutor does have an ongoing investigation into the situation in Israel and Palestine, looking at potential crimes committed by all sides since June 2014. Human Rights Watch, for instance, has urged the prosecutor to be very clear about how the ICC mandate applies right now, stressing accountability.
Okay, so ICJ for state obligations, ICC for individual criminal responsibility. Now let's bring it all together. How does international humanitarian law, IHL, apply specifically in the Israel-Gaza situation, according to the sources?
Right. IHL, or the laws of war, governs conduct during armed conflict and occupation. It binds states, like Israel, but also non-state armed groups, like Hamas and Islamic Jihad. Critically, it's non-reciprocal.
Meaning one side's violations don't excuse the others.
Exactly. Violations by one party never justify violations by another. IHL applies during conflict or occupation, while human rights law applies all the time. IHL focuses on how hostilities are conducted, not why they started.
What are the bedrock principles we need to keep in mind?
3 key ones. Distinction: always distinguish between combatants and civilians. Only target combatants and military objectives.
Okay.
Precaution: take all feasible precautions to minimize harm to civilians and civilian objects. Think warnings, choosing targets carefully, avoiding populated areas if possible. And proportionality: don't launch an attack if the expected civilian harm would be excessive compared to the anticipated direct military advantage. It's a balancing act, but civilian harm can't be wildly out of proportion.
And treatment of people in custody.
Humane treatment is mandatory. Hostage-taking is absolutely prohibited, as is using human shields. Also, effective advance warnings should be given for attacks affecting civilians, unless circumstances make it impossible. But a warning doesn't remove the duty to protect them.
And the occupation status. You mentioned Israel is considered the occupying powers in '67. Does the 2005 Gaza withdrawal change that legally?
According to the prevailing view in international law, including bodies like the UN and ICRC, no. Despite pulling out ground troops, Israel is seen as maintaining effective control over Gaza-controlling borders, except Rafah, airspace, territorial waters, movement of goods and people, population registry, infrastructure links. Because of this ongoing control, it retains the obligations of an occupying power under IHL.
Which includes ensuring humane treatment and basic needs.
Yes, ensuring food, medical care, hygiene, etc., as laid out in GCIV Article 56 and others.
Let's talk about war crimes. How are they defined in this context, and what specific allegations are being raised by the sources like Human Rights Watch or OCHA?
War crimes are serious violations of IHL committed with criminal intent deliberately or recklessly. Examples include targeting civilians, hostage-taking, collective punishment. Sources allege potential war crimes by both sides. Hamas's deliberate killing of Israeli civilians on October 7th and taking hostages are cited as clear war crimes. Their indiscriminate rocket attacks into Israel are also war crimes.
And regarding Israeli actions?
Concerns raised include Israel's heavy bombardment of Gaza, the high civilian death toll, including thousands of children, and destruction of entire neighborhoods, raising questions about indiscriminate and disproportionate attacks. The reported use of white phosphorus in populated areas is another serious concern.
What about the siege-like conditions?
Israel's cutting off or severely restricting food, water, electricity, and fuel for Gaza's entire population is argued by many, including human rights groups and UN officials, to constitute collective punishment, a war crime. Willfully impeding humanitarian relief is also a war crime.
And the OCHA reports paint a grim picture of that.
Extremely grim. As of late April 2025, OCHA reported a nearly 2-month blockade on most aid entry. Food stocks running out, critical shortages. They also report increased attacks on tense housing displaced people with horrific casualties, including children burned alive. Hundreds of thousands newly displaced with nowhere safe to go.
The humanitarian situation sounds catastrophic.
OCHA described it as possibly the worst crisis since October 2023 due to the bombardment and aid blockade. Humanitarian operations are crippled military activity. The blockade itself attacks on aid workers.
How many aid workers?
OCHA reported at least 418 killed since October 2023, including 295 UN staff as of late April 2025. Movement restrictions are severe. 95% of surveyed aid groups had suspended or drastically cut services by late March 2025. It's incredibly dangerous and difficult to operate.
There are also concerns about displacement orders.
Yes. Forcing civilians to move is only allowed under IHL for their own security or imperative military reasons, and crucially, they must be allowed to return. Permanent displacement is a violation. Transferring the occupier's own population into occupied territory settlements is also a war crime.
And Human Rights Watch mentioned broader crimes.
Yes. HRW has stated that Israeli authorities are committing the crimes against humanity of apartheid and persecution against Palestinians, viewing the Gaza situation as part of that broader context.
The OCHA reports mention other specific issues, too.
Yes, lots of detail. Destruction of heavy equipment needed for things like clearing debris or water supply repairs. Massive food price hikes, 150 to 700% increases. Essential foods disappearing from markets. Rapidly worsening nutrition, especially among children, but screening sites closing due to insecurity. The health system is collapsing, shortages of everything, facilities under displacement orders. Continued attacks on journalists, 210 killed since October 2023. Fishers facing extreme risks. Awful conditions in IDP sites, lack of food, water, hygiene. Water shortages despite some pipeline repairs due to network damage and fuel shortages. Sewage infrastructure damage leading to major public health risks. All this is happening as the ICJ hearings proceed.
It's an overwhelming convergence of legal issues and human suffering. Briefly, what about state responsibility?
It's a complex area, but basically international law holds states responsible for internationally wrongful acts like breaching IHL. The ICJ has played a big role here. There's also this growing idea of erga omnes obligations. Obligations owed to the entire international community, like prohibiting genocide or apartheid. All states arguably have an interest in seeing these upheld, which opens doors for things like the South Africa case at the ICJ, sometimes called community interest litigation.
Okay. So, considering everything we've unpacked, the detailed rules of the Fourth Geneva Convention, the ICJ's deliberations, the ICC's potential role, the specific IHL principles, and the truly devastating reports from OCHA and human rights groups, it leads to a tough question. What does it genuinely mean for the world, for the international community, to uphold its promise to protect civilians in conflict? How can these legal frameworks we've talked about become more effective tools, not just documents, to ensure accountability and actually relieve the immense suffering we see in places like Israel and Gaza today? It really makes you think.
It certainly does.
Thank you, The Learner, for joining us on this really demanding deep dive. We genuinely hope it's offered some clarity on the legal side and the human side of this incredibly difficult situation.
And remember, this isn't the end of the conversation. The sources we mentioned, GCIV, ICJ documents, HRW, OCA reports, they offer so much more detail if you want to keep exploring.
Absolutely, please do.
And maybe just one final thought to leave with you. May our collective engagement with this kind of knowledge, however difficult, somehow blossom into deeper understanding and hopefully a more compassionate world.
Well said. If this deep dive sparks something for you, please share it, like it, subscribe to the All Sorts podcast on YouTube, check out our archives for other discussions, and join the conversation on X, Instagram, and Threads. Let's keep talking about these important issues.
Keep seeking.
Keep learning. Until the next deep dive.